State of Wisconsin versus Jessy R. Kurczewski, case number 21CF885. May I have the appearances, please?
Abby Nikolai, Randy Sitzberger, and J.J. Crawford are appearing for the state. Good morning, Judge.
Attorney Gallivis and Attorney Kukler sitting here with our client, Jessy Kurczewski, sitting at the end in custody. Good morning, Judge.
All right, good morning. We are here today for the juror questionnaire conference. Has the state complied with victim rights?
Yes.
And just a note for everyone, the media is present today. They are recording, so if anyone is, just be mindful of that cameras are capturing this and may capture anyone coming and going in the courtroom while court is in session.
Thank you.
There is the trial administration order, and it does apply to today to the extent that it can be complied with. Obviously, that trial administration order contemplates a little bit different setup with microphones and cameras, but other than that, it would apply. I know the parties have met and conferred. I have some documents related to that in terms of there are some stipulated strikes for cause. I appreciate the parties reaching agreement on that. There is a request from the defense. I believe it's 44 individual jurors, and then a request from the state, another 4. Please be mindful, since this is being recorded, and there is the order regarding the numbered juries. I believe that's document 162, to only refer to the jurors by one of their numbers, and not. It's probably best if we rely upon their pool number. Madam Clerk, I know you looked at the list more carefully. Which number did the parties utilize most?
Juror ID number.
All right, then we'll switch that and we'll go to the juror ID number when referring to any particular juror. I know the state also had filed a letter indicating that there was a request that I address the following outstanding issues, with the exception of the defense amended witness list. There are a number of items I would call evidentiary, perhaps issues. I had an opportunity to re-listen to the jury status from January of this year, where many of these topics were raised. At that time, the February 13th trial still remained. I'd given an extension of a deadline in terms of addressing any of those things by motion in limine. Nothing was filed by that. I also had done an amended trial order once the trial was adjourned, and no motions have been filed related to these topics. And so I'm not going to make any pretrial rulings as it relates to any of these topics. I will rely on the adversarial process during the trial. And so I'm not saying one way or the other whether something comes in or it doesn't. So I'll just rely upon that and make rulings as need be. There can be certainly many reasons why a party objects or doesn't object. And so given that there are no motions in limine that were filed, that's how I will address the letter from the state. I know I also had referenced in that prior jury status regarding a cautionary instruction regarding Ms. Kurczewski being in custody at times. To date, I have not received any such request. I may, in my own discretion, draft something if I feel it is appropriate. But I'll wait and see how the testimony and evidence comes in, and ultimately if there is a request. It would be something very general from my perspective if the jurors were given some type of a cautionary instruction, something to the effect of, at times there may be reference to Ms. Kurczewski being in custody. Her custodial status at any point in time during the investigation has no bearing on her guilt or innocence and may not be used by the jury in any way, something to that effect. But again, I'll wait and see what the defense does with that. Since it's a single issue related to this amended juror list, it's a second addendum list of defense witnesses. Let's just deal with this initially, and then we'll jump into the jury questionnaire conference. The state requested that I address it, but all that is listed on your letter is an offer of proof. So please tell me what the objection is or what you're looking for.
Judge, we'd first object because it's untimely. There's been, as the court has already referenced, a series of orders and trial scheduling orders in this case. Adding defense witnesses to this case is the reason that it's not been completed when it was scheduled to be completed in February of this year. And yet we have another new person filed, I think, around 2 p.m. yesterday by the defense. And so we're objecting to that person testifying based on that being a blatant violation of all this court's scheduling orders. If the court is unwilling to do that today, we're simply asking for an offer of proof, perhaps a date of birth for this individual so that we can do what we need to do before the 23rd.
Paragraph 5 of the trial order issued by this court and filed as document 202, filed on April 21 of 2023, said the following: disclosure of lay witnesses has already occurred. Any additional witness named by either party must be filed no later than June 15 of 2023. The naming of any additional lay witnesses beyond June 15, 2023 will only be allowed upon motion for good cause shown. Disclosure of expert witnesses has already occurred. The court has extended the time for the defendant to name an expert in the field of pathology to June 15 of 2023. The notice shall include the name of the expert, CV and summary of the proposed testimony. The naming of any other or additional expert witnesses will only be allowed upon motion for good cause shown. I don't have any motion before me today. I just have this filing. Why should the court even entertain the naming of this witness, Attorney Galaviz? Attorney Kukler, I guess you'll be the one addressing that.
Okay, Judge, in prepping for trial, this is a witness that is in the state's discovery that they provided to us, so it's not a surprise person. I saw the name in reviewing some of the financial records. So it's a person that was involved at one of the banks, and the state does not have him listed on their list, but he was involved in the case. So I've determined that although his testimony would be brief, probably no more than 15 minutes, he does have important information to offer. We can file a motion requesting for good cause and we should do that.
Given the trial order in this case, I'm going to deny the request at this point in time. You indicated you understand you may need to file a motion. I'll wait and see if that motion is filed, but at this time, the witness is not allowed. All right, then let's move on to the jury questionnaire conference. Given the stipulation of the parties as to a number of the jurors, any objection from the state if I strike those jurors for cause at this time?
I'm sorry, the stipulated list?
The stipulated list.
No objection from the state, thank you.
Any objection from the defense?
No.
All right, then the jurors that were indicated on the previous filing as being stipulated to, the court will strike for cause. There were, I believe, 18 were listed. My understanding is one, which is number 9, and document 231 had already been excused.
That's my understanding, Judge.
Our understanding as well.
All right, and there were 2 typos as to numbers. Number 2 should have been 7814, and number 4 should have been 695. You might want to verify that first, but that's my understanding, right, Madam Clerk?
No, I don't think so.
I think it was just a reference to the wrong number.
Yeah, in one case, they used the pool number instead of the juror ID number. So number 2 in the stipulated was listed as 0756, but was corrected to 7814. And then number 4 was corrected from 0852 to 695.
Right, it's just to be consistent that they're all identified by the same number. It's the same person.
I think that's the same for number 17 then.
And
Number 17 should be 6584.
All right,
I would
that's
agree with
not on my list, but do you agree with that?
Yes.
All right. Just, I will read them into the record just so it's clear, and then you can tell me. 7403, 7814, 4521.
No.
4521 is number 3. I'm sorry, 4541. I said that wrong. Thank you. See, this is why we have these conferences. 4541 is number 3. 695, 268, 4337, 4450, 4424, 608 was already struck, or excused, one of the two. 7227, 5712, 285, 2052, 3207, 4302, 5870, 6584, and 6728. Did I miss anyone? Attorney Nikolai?
No.
Attorney Kukler?
No.
All right. All right, then we'll turn next to the request by the state. There are 4.
I'm sorry, Judge, could we just have a minute? We're having trouble finding these numbers that were incorrectly on the list.
Thank you. 756 doesn't seem right.
$756.
756 will be 7814. So pool number 756, but juror ID 7814.
Yes.
Yes.
That's, we agree.
Yes?
Yes.
And then 0852 would be 695.
And we didn't agree to,
That's on the list. And then you just confirmed it.
So
695? I agree that's what that number's been changed to.
You have 0852 as number 4.
and
Yes,
The juror ID number 695.
yes. I agree. That's what the state requested, and we agreed to it.
We were
I
thinking
know.
695.
this is this one?
Yeah.
Abby, do you want to see your email? It's right here. It's on this email. We're using one.
And then 6382,
Pardon me, Judge?
number 17, should be 6584.
Right.
Right. Yes,
Okay.
that's correct.
Thank you.
Which, actually, I think maybe the confusion was, the pool number was 655 for that person? Sorry, 955. And then the number, instead of the 6382, is 6584. That may be the confusion.
We agree on striking 6584 for the record.
That's the state's recollection as well?
6584.
Right, that's the juror ID, the pool number 955. Madam Clerk, how did you come up?
6584, the pool number for that is 969. I have an email that told me that 6382 was in the strikes for cause and also in the defense's request.
Right.
6382 was to stay in the defense request for strikes, but then 6382 in the stipulated should have been 6584.
Right.
Which is a pool number of 969.
Okay, thank you.
Okay, well, that's wrong on mine.
Well, I just had to do the addendum on mine.
So what was the pool number? 695?
969.
969, okay. Well, I said 955, my apologies. I have a spreadsheet I'm working off of, and it's not correct. One on my computer is. All right, so I believe we're good to go on all of the stipulated strikes for cause. All right, let's move on to the 4 requests by the state, starting with juror ID number 1073. And the basis,
Well, you're starting with the number 4 on their list? Okay, excuse me, I had them in the wrong order.
I have them in the actual order, numerical order is how I order them. I can flip if you need be.
Ready?
I'm ready as well, as long as the census.
We're ready.
All right. Attorney Nicolai, will you be addressing these?
Yes, thank you. In terms of this request, the state in reviewing the questionnaire, the basis for the request is that the individual appears to be someone who is very religious and also is someone who, because of their beliefs, indicated that they would have trouble putting someone away in jail, is the quote, even with a murder charge. And so from our perspective, that is someone who is indicating very honestly that they would not be able to be fair, considering, I think that any jury hearing a homicide case is going to know that on a conviction, the person is going to be serving some custody time. I would say that this may not be a request had we been preparing a OWI trial or something of that sort, but the fact that it is a murder charge and that's specifically what this juror cited having trouble with is the basis for our request. She indicated she would feel bad if I had to put someone away in jail.
All right, what's the defense position?
Well, we object to this person being struck at this point. I think it's premature, possibly. I think there could be some further questioning of the person. We don't strike people because they're very religious, number one. That isn't a basis. The person indicates that they may feel bad if I had to put someone away in jail. That's not a basis to remove them from the panel. Probably most people feel bad in some ways having to deliberate and reach a verdict, but I didn't think that this would qualify.
I'm going to
Judge,
deny.
to clarify the record, I was not in any way suggesting that because this woman has religious beliefs, she's not qualified to be a juror, and that was what was suggested.
All right, thank you. I believe the request to strike for cause is premature. First of all, it is not the role of the jury to concern themselves with sentencing issues. There's obviously a jury instruction on that. While perhaps her answer would raise an eyebrow as it relates to whether she would have make a decision based on sympathy, I believe further follow-up is required to find out if she has formed any opinions or if she could set that aside. One of the standard questions that this court asks an individual when there is a question that raises a concern would be, are you able to put your feelings or opinions aside and decide this case based solely on the evidence presented and the law as the court defines it for you? And also to reiterate with that juror that they cannot make a decision based on sympathy, and to remind the jurors that they also need to make a decision that does not take into account any, the consequences of their verdict is the language of the jury instruction. So I will deny the request as it relates to juror 1073. That'll stay in the pile then. All right, moving next then to juror 1476.
Thanks, Judge. This basis for this request is that this juror indicated they hired Anthony Cotton recently to represent the juror's brother in an extradition. Given that Anthony Cotton is in the same firm as Attorney Kukler, that was the basis for this request.
And your legal support for exclusion at this time?
That this juror potentially knows one of the parties involved.
You mean one of the attorneys?
Right.
I don't think knowledge alone is sufficient, but what's the defense position?
We don't think this person be struck just because they know somebody in my law firm. It wasn't for, didn't hire our firm for themselves in any event. It was for some brother's case. I don't personally even remember this case. And I don't think that jurors know somebody in the district attorney's office or know somebody just on its surface. It would be because they are involved with it as a basis to strike.
I think follow-up is needed as it relates to this juror as well. We're somewhat speculating that there would be a bias, if you will, for the against the state or some type of, imputation in a good way to the defense because Attorney Anthony Cotton is the son of Attorney Donna Kukler. We don't even know if they've ever met. We don't know at this point if Attorney Kukler herself made any appearances on the case. I think that would change my analysis, but no one's presented me with those facts. Just like the previous juror, I think more follow-up is needed and very specific questions regarding this particular juror's familiarity with the firm of Kukler and Cotton needs to be explored, but nothing at this point rises to the level of any type of bias, objective or subjective. All right, so that'll be denied as well, and that juror shall remain in. All right, then moving on to number 2325. Go ahead.
Thanks, Judge. This individual lives in Milwaukee. This is the basis for our request. The address he provided is on 59th Street in Milwaukee.
Well, that would most likely take them out of criteria. You agree with that, Attorney Kukler?
Yes, absolutely.
All right, so 2325 is struck as not being qualified because the juror lives outside the county. All right, 6178.
This juror caused concern to the state because of comments regarding self-admitted discriminative thoughts about certain races and sexuality choices. Out of an abundance of caution, we flagged this person and are asking that they be struck based on that comment. Attorney Pablo Galaviz obviously could potentially be the type of person this juror is indicating they discriminate against. And that's really the basis. I guess if the defense objects to that request, I would withdraw it.
Attorney Kukler?
Yeah, I think that we will agree to this one after giving it second thought. We'll agree to this one to be removed.
All right, then based upon the agreement of the parties, I won't stand in the way of that, and juror 6178 is struck. Okay, thank you. That gets us through the state's requests. And then Attorney Kukler, will you be addressing the defense strikes for cause?
I can do that.
And again, I have them in numerical order based upon their juror ID number. So do you need a moment to?
Just let me put this away. I have mine in order by juror number 2.
All right,
So we should be
497
good.
should be the first one.
We're asking that 497 be struck because this person is a police captain at the Brookfield Police Department and knows all the Waukesha district attorneys.
Have you read State versus Lewis, 156, the second 470?
No, I haven't.
Are you aware that our Supreme Court indicated that police officers, even those with knowledge of other witnesses, that are per se ineligible to serve as jurors? There's an extensive discussion in that case. I think it's directly on point.
In
The
addition-
Constitution and even our statutes really make very clear that exclusion based on groups should not be a basis without more information.
I think you have more information.
Right, it's possible.
No, I have more information.
Oh, you have, what is the additional information?
The additional information is also that his mother is in hospice for heart and spine care, and he is one of her assistants, and it would be very difficult for him to assist her if he was in a 5-week trial. So given all of those reasons, we ask that the court excuse him.
Just a note on hardship. If I were to exclude everyone who claimed a hardship without questioning further, I would dramatically limit this jury pool, and I don't think that's a basis. This is an obligation that citizens have to serve on a jury. Certainly, a hardship could rise to an issue if they're not able to be objective, or if they identify some other type of bias. But I think just the identity of a hardship in and of itself is not a basis to exclude or strike a juror for cause, because it does not evidence any type of bias or prejudice on the part of the juror. If there's any additional law you would want me to consider, please let me know. Anything else on that, Attorney Kukler?
No?
What's the state's response?
We are objecting to the motion to strike for cause. This individual, it's premature, and I think more information would need to be obtained. That's all I'll say about that.
All right, I'll deny the request as to 497. Was this one on a stipulated list?
16 should be the next.
No, but I'm looking at the letter from 1011. Was that someone who was stipulated to, the 285?
I think so.
Okay, let me just look at my list again. Oh, yes, it was, okay.
Agreed.
I'm looking at your letter with your listing and realize I started with the second person, but that's because the first person, there was a stipulation too. Okay, then let's move on to juror number 629, Attorney Kukler.
I think this person, everyone's got a hardship, so there's no doubt that we are hearing hardship. For many people, this one has a particular hardship because of the employment. It's outlined on page 7. Detrimental to his company, can't reassign all the responsibilities for that amount of time, oversees 14 full-time employees. It's just a little bit too much it's too much for this particular person. We're asked that he be excused. for such a long trial.
What's the state's response?
Judge, we're just looking, because there's some indication that we had this person was postponed recently by the court already. Nonetheless, we would object because there's not enough information about this individual to strike for cause.
I'll have Madam Clerk reach out to our jury coordinator, Lauren, to find out. They are still on my list and my spreadsheet that I've been working off of. Nonetheless, I'll deny the request to strike for cause. Again, I think we're premature. We don't know anything about this company, whether it's a, is it a two-man accounting position in this company. The person looks like they're in accounting, but they work for I don't know if it's a larger company, a smaller company. We don't know really what the basis of the hardship is, other than what's explained in the jury questionnaire. But I think we need to ask this individual more questions and then find out if at that point in time it would be appropriate. But again, I stated this earlier, a hardship alone is not going to rise to the level of being struck for cause. Maybe later on in my discretion, but not at this point. So 629 remains. All right, 811.
Yes, Your Honor, we have asked that various people who are victims of theft and robbery be struck, given the nature of the case, and this is one of those individuals. That's the basis.
Attorney Nicolai.
We'll be lodging objections to this series of individuals. There is more than just burglary, robbery, and theft victims that are on this list, and the victim has an absolute right to participate in the criminal justice system as a juror when appropriate. So we'll be lodging this objection to several of these individuals. We simply don't know enough about this juror to strike her for cause at this point.
I would agree. It's premature at this point in time. We don't know anything about the nature of the crime listed by the victim. We don't know if there are, similarities or not. And even so, I ask jurors routinely who come into court with some experience that might touch on one of the crimes that are charged, are you able to put aside your feelings or your opinion or even your experience and decide the case based solely on the evidence presented in the law as the court defines it for you? I owe it to all of those potential jurors to ask them that question to find out whether they have any type of bias. But every juror comes into the courtroom presumed to be fair and impartial, and nothing about just being identified as a victim of a crime changes that without more. So 811 is denied and will remain in the pool. Juror 870 then?
Thank you. 870 has indicated that her mother recently died, and that causes her to have problems sitting on this case. In addition, the person has sleep apnea, is unable to concentrate in the afternoons, and sometimes falls asleep sitting up. And somebody like that, we need people who can pay attention in court.
What's the state's position?
We are objecting to this. I think we need more information. The defense also noted on its filing that the first reason listed was because this individual is also the victim in a criminal case. So more follow-up would be needed with her. I know this court routinely takes stand-up breaks for the jurors because anyone can get tired in the afternoons, and so we'd ask to flesh this out more if she does make the box at jury selection.
This particular juror was flagged by the defense for a variety of reasons, but what concerns the court most is the identification of a condition that may interfere with this person's ability to concentrate in the afternoon, indicating that they sometimes fall asleep sitting up. If this were a 2-day trial, a 3-day trial, even a week-long trial, I wouldn't have this same concern, but this is a 5-week trial with, even with standing breaks and other things that out of an abundance of caution, I don't think this person is appropriate, and I'll grant the request as to 870. All right, 1261 then.
1261 is a person that also is, in this particular case, is a victim of ID theft. And we're asking that, in addition to being a victim of ID theft, the person's job requires them to be available, according to question 51. Although the person said they would do their civic duties, if called upon in 53, they asked to be a last resort. They think that this is not the right trial for 1261.
What's the state's position?
We would object. This is very close to just excluding a class of people because they've been victims of crime. Again, many people cited a hardship in regard to their employment as well.
I agree with the state. The request is denied. I will not exclude based upon a class of being a victim of a crime without more. Any issue or concern this juror had with the length of the trial is diminished by that juror's own answer. They clearly understand the importance of the civic duty, so we can certainly ask more questions at the appropriate time, but the request for 1261 is denied. All right, then turning next to 1393.
1393 is also a robbery victim, but in addition, there's more important information in that the person is a nanny and is responsible for care of another family's children. They depend upon her, and they provided detailed information about that. Furthermore, they will not get paid if off of work, and this person who is depends on this income would be unable to pay her bills if required to serve for 5 weeks. I think that's an extreme hardship to somebody who can't pay their bills.
What's the state's position?
We don't have an objection.
All right, based upon there being no objection, then I won't stand in the way of an agreement, and 1393 is struck. All right, number 1405 then?
Thank you. 1405 has indicated, and of course we offer assistive hearing devices to people, but this person has chronic ringing in their left ear, and in addition to the hearing loss, in addition to the migraines that happen that cause fatigue. And in a 5-week trial, I think that this is not the trial for this particular person who has the migraines that cause fatigue, doesn't know what would happen during the trial, hearing loss and chronic ringing in the left ear. This is a case where people have to pay very close attention to what's going on. It's going to be going on for 5 weeks, 4 weeks at least. And that's our basis for juror 1405.
Attorney Nicolai.
We're objecting to this. We think those concerns could be something that this court would be able to accommodate. Additionally, this is another individual who is a victim of a crime. So we don't think that this additional information regarding the hearing loss is enough to escape the reality that this would just be a class-type exclusion based on our status as a victim.
I believe it's premature to exclude 1405 at this time, in part because the reference to migraines is that it is occasional. The hearing loss is something this court can certainly accommodate, and often does. Had many trials where there is a juror with the headphones or the assisted listening device. We just simply need more information, and of course, I will not exclude based upon a class of being a victim. So for all those reasons, I'll deny the request as to 1405. All right, turning next to 1988.
1988 manages a small nonprofit and has no one that can do her work. Even when she's on vacation, she has to work. She has animals and has no one who can take care of them, of her animals. In addition, indicates that she cannot be objective because her neighbor got off after her neighbor shot her dog. In other words, the neighbor shot 1988's dog and got off, and indicates that she can't be objective. So for that combination of reasons, we feel this is a person that should be struck.
What's the state's position?
We're objecting to this individual as well. I think that more information would need to be obtained regarding what she meant by not being objective, since she related it directly to a very specific instance of, a criminal law violation in terms of killing a domestic pet, and that's not at all involved in this case. Additionally, I think she, like many others, would have a hardship not being at work, but I don't think we have enough information about that either at this point.
I believe it's premature to exclude 1988. While certainly there are some concerns with some of the answers, she needs to be given an opportunity to explain. There's also a very different type of crime that she references, not part of the allegations in this case, that being mistreatment of an animal. And so I will deny the request as to 1988, and she'll remain in at this point. Turning next to 2334.
Two, 3, 3, 4 is a victim also of an assault, which of course this court has made clear that that's not going to be a basis to exclude her. Indicates that if the case has been on the news, she may already know about it. That's basically it, Your Honor.
State's position.
We're objecting to striking this juror for cause. I think more questions need to be asked in regard to both of the criteria outlined by defense.
It is premature at this point to find that there's any type of bias or prejudice or anything of concern related to this particular juror. Case law makes clear that even being at an event that is the subject of the lawsuit or case is not grounds in and of itself. It warrants further explanation. She does not provide any details and in fact makes reference to the wrong case as to what she has knowledge of. So we'll certainly have follow-up questions for her, but at this time the request to strike is denied. Number 2398.
We were concerned about 2398 primarily because she doesn't really read, and then also is a stalking victim. There's going to be reading involved in this case.
All right, what's the state's position?
Thanks, Judge. The status as a victim of stalking is not appropriate to strike her for cause. The answer this juror gave regarding not reading was in response to a question about what her favorite types of books are. She did not indicate that she cannot read, so we're objecting to this.
I believe it's premature based upon the answers provided by this juror. We don't know if it's a complete inability to read or if any accommodation could be provided. And being a victim of a crime is not an appropriate ground to be struck for cause, so I'll deny the request as to 2398. All right, turning next to 2607.
We'll withdraw the request to strike for cause that person.
All right, then 2607 will remain in. I presume there's no objection from the state to that.
No.
Okay. Then turning next to 2755.
2755 is a close friend with Judge Horlocker. And is a victim of a sexual assault.
State's position.
We're objecting to this request as well. Same objection on the victim status, and then in terms of Judge Horlocker, obviously, he's not presiding over this case and is not even in the criminal bench at this point, so I don't think that's an appropriate reason to strike him for cause.
None of the concerning aspects raised by the defense rise to the level of any type of bias, subjective or objective. Being close friends with a judge on the Waukesha County bench in and of itself is not grounds to strike that person, and again, I won't strike anyone at this point for being a victim of a crime without anything more. So the request is a 2755 is denied. All right, then looking at the next one, Juror 3000, I've read
Yes.
through State versus Toddy, which is from 2008, 2009, WIS 31, a little bit different situation. That was the mother of the presiding judge was on the jury panel, and our Supreme Court said that just crossed a line and a conviction was reversed. This is not, and I won't say the relationship because these jurors are confidential, and I think one could potentially figure that out. It's someone who, not at the moment, but in the near future, will be related by marriage to me. So what's the state's position on this one?
We don't have a position on that, Judge.
I think out of an abundance of caution, given the Toddy case, and in my discretion, if it's still the request of the defense, that I would grant this request. And I presume it is, right? It's still your request that they be struck?
Yes.
All right, and again, out of an abundance of caution under State versus Toddy, I think this person would not be appropriate for this particular trial. All right, turning next to juror number 3207.
Well, that was a stipulated,
Oh,
was
there
it?
you go. We'll take that one out. How about 3329?
3329 is, we're asking for the person to be struck. Their home was robbed by a cleaning lady. Given the nature of the allegations here, it seems that they might not be able to be fair and impartial. They're also the primary income source for the family and scheduled to be out of town November 23rd through November 27th. The person is also a commission-based employee, so doesn't earn commissions when they're working.
As an aside, November 23 and 24, we are not in court on those days because that is the Thanksgiving holiday. The 27th is that Monday. We are still scheduled, although I am still hopeful we'll get done before the Thanksgiving holiday. But I wanted to make a record that the dates that he claims would be over the Thanksgiving holiday, and I think we would be able to accommodate that if, in fact, we're still going at that point in time, meaning I don't believe that presents an issue for the court. But what about the other issues raised by the defense?
The state would lodge the same objection regarding the class of victims of crimes. That should not be a basis to strike this individual. And then the hardship in the work and income source, I don't think, we've agreed to some of those when they appear to be an extreme hardship, but we didn't think that this one rose to that level.
I think it's premature. We don't know enough about the business, whether it's, one or two person small business versus a large corporation where maybe the work could be absorbed, things of that nature. I've already commented upon the time being off. Court's going to be down in any event other than that Monday. I'd certainly want to know more information about when the trip was scheduled, whether the person could be back by the 27th, if in fact we're still in session, et cetera. So it's premature at this time, so I'll deny the request as the 3329. All right, turning next to 3515.
3515 indicates that after losing his mother and his dog within 2 months, and he says that he were the only 3 in the house, on top of COVID, everything changed. He's very stressed. After dealing with grief for a while, he got another dog. His brother's disabled, his sister works. He doesn't know how he could leave him alone all day for 5 weeks. He is dealing with, in his words, extreme grief.
What's the state's position?
We don't have an objection.
All right, there being no objection, I won't stand in the way, and 3515 will be struck. All right, juror 3651.
The only basis was being a car theft victim, so we can withdraw that one.
Any objection?
No.
All right, 3651 remains. Juror number 3674.
3674 has indicated that there are personal reasons that he cannot serve on this jury, and we're, out of respect to whatever those personal reasons are, we're asking the court to excuse him from this trial.
State's position.
I think that more questions need to be raised with this juror. The answers on the questionnaire were either non-existent or very, very vague.
I agree. It would be premature to find that there's any bias or prejudice on the part of this juror. More information is needed, so I'll deny the request as to 3674. All right, juror number 3766.
The court struck.
Oh, I did. I guess we're moving on to... Hold on. So 3766 was already struck.
That's right.
All right, so I have next four.
4302 was stipulated now.
Yep, all right, so that person's already, okay, I'm on,
It's 4337,
That's what we have.
what about 4337?
Yes, we're asking if 433,
It is a duplicate, that was somewhere else? Okay. Hold on, well, what would be the number then?
We would be on 4401 next.
No, what, hold on, what would be the number for, that's the duplicate 4337?
They were in the stipulated list.
They were in the stipulated list, all right, I believe 4337. Let me double check. Yes, that person's already been struck.
no.
So we are on 4401.
four 401 is visually impaired, doesn't drive. And by the way, there's a lot of financial documents here that need to be able to be seen, that the state will be introducing into evidence.
It
So
doesn't indicate she's blind, though, and she watches
No.
TV shows, so.
I didn't say she was blind. She said visually impaired. And they do not drive. Because, I mean, it's visually impaired dash do not drive. So person doesn't drive and is visually impaired. This is a complicated case that requires vision, good vision.
Attorney Nicolai on 4401.
Judge, we're objecting. This appears to be a class-type exclusion based on disability.
We don't have enough information. I agree it might certainly be important to be able to, you know, review the evidence, whether that's reading it, seeing it, hearing it. We don't have enough information, and that includes her ability to get to the courthouse each day. So we'll take a wait-and-see approach. I'll deny 4401. Uh, 4424 was already agreed to,
Yes.
so we're on 4432.
Based upon the court's position that being a victim of a crime is insufficient, we'll withdraw.
All right, we'll certainly can ask more questions at the time of the jury instruction conference, but they'll remain in. Thank you. All right, we should be at 4450 was already a stipulation,
Right.
Yes.
and 4452 would be the next individual.
4542, I show, is that right?
If I flip the numbers, you are correct. 4542.
We are asking that 4542 be struck due to his being a retired Wauwatosa and Milwaukee police officer and involved for his entire career in the prosecution of crimes.
Given the holding in State versus Lewis, that police officers in and of themselves are not a class that should be struck per se, I'll deny the request at this time. 4542 will remain. All right, 4558.
4558, the court's indicated at the start of the hearing today that you're going to possibly come up with some cautionary jury instruction indicating that to explain when our client has been in custody at different times while the case was pending. This particular person indicates that he will not be impartial if the defendant has a record. And it's going to be very clear that this person has custodial statuses, and therefore a record.
State's position.
And I'm sorry, one more thing, because of course the court granted the state's other acts motion as well. So that's coming in. That's
Attorney
all.
Nicolai.
We are objecting. I don't think that at this point we can assume this juror is going to disregard the jury instructions which will be given regarding not only the defendant's custodial status previously, but also those other acts. We did put together a proposed instruction for those other acts, provided it to defense counsel, but nonetheless, something will be read to the jury about those other acts and the appropriate purposes of considering them. So I think that it's possible that if he's in the panel, he could answer in a way that he would be struck for cause, but I think it's premature.
I believe it's premature as well. The request will be denied. I would note that where he indicates his lack of partiality would not be the type of case this involves. He specifically references use of force by police, a person defending themselves against an aggressor. He does say or prior criminal, but I think more questions are warranted. He comes into the courtroom presumed to be fair and impartial, and I believe I owe him the opportunity to ask whether he can set aside his prior feelings or opinions and decide the case based solely on the evidence presented and the law as the court defines it for him, and if need be, even tell him very specifically he may not use any evidence of a custodial status against the defendant in any way. So the request as to 458 is denied. 4558, excuse me. All right, turning next to 4584.
4584 has no transportation. I think it's terrible burden to expect somebody 70 years old who has no transportation to participate in a 5-week trial.
What's the state's position?
This individual was also the victim of an ID theft, and so I think that the added information of having transportation issues is not enough to strike this person for cause. I think there needs to be more discussion regarding any possible solutions to that problem before he's struck for cause.
I'm not asking he be struck because he's a victim of a theft. I'm asking because the man doesn't have any way to get to and from court for a 5-week trial, that it's terribly burdensome to expect him to participate.
I can't make that finding yet. I would note when it says, where do you work? The place that he works for has a St. Paul, Minnesota address, so I'm assuming it's maybe a parent corporation or something, but I shouldn't make that assumption either.
He says retired, Judge. He says retired.
Oh, he's retired. Sorry, I was looking at a different part. It said, what kind of work do you do? But that would be in the past. So he's retired. So he lives in
Delafield.
Waukesha County. Thank you. And I have questions. I'm not unsympathetic to someone who may not have transportation, but, you know, where does he go to get groceries? How does he do that? Does he have any friends or relatives? You know, there is potentially an accommodation that could be provided. And so I think that fact alone warrants further exploration during the jury selection process, rather than a strike for cause at this point in time. So that request is denied. All right, moving next to juror 4588.
4588, we're asking to be struck for cause. Your Honor, this case involves a death, and of course there will be testimony from a medical examiner. There will be autopsy photos, presumably, and there will be, and this person has indicated, 1, he will pass out if there's any graphic images. 2, can't watch blood. Autopsy photos have blood in them. He's had 4 funerals this year. He's struggling emotionally with all the death in his personal life. And so for those reasons, he's not appropriate for this particular jury.
What's the state's position?
I don't have a position on this request.
When I look at the totality of this individual's answers, including some detail provided regarding one of the deaths, which what I would characterize as a homicide-suicide, and then the squeamishness, out of an abundance of caution and in my discretion, I'm going to grant the request to strike 4588 for cause. All right, turning next to 4722.
Your Honor, we're asking that 4722 be struck due to a couple reasons. 1, this person is a fraud strategist for a national bank, and there's allegations of that type of behavior here. I don't think that person can be fair and impartial, given the nature of that employment. In addition, the person has anxiety. The person has insomnia and is concerned with the effects of the trial on her health. She is also lost her dad recently and is assisting her mom as a caregiver. Her mom is in assisted living, and she is the caregiver for her mother. And given that combination, of reasons we think this person should be excused from this particular trial.
What's the state's position?
We're objecting to this request. The first reason enumerated in the defense filing document 232 is the fact this juror is a fraud strategist for a bank. That class of employment is not appropriate for a reason to strike, and everything else that's been recited, there's simply not enough information regarding how much of a hardship any of that really would be. I think it's premature, and we would need to ask her many more questions before striking her for cause.
None of the answers provided by 4722 identify any type of bias or prejudice. Just working as a fraud specialist in and of itself would not be grounds for this court to strike this juror for cause. As with many of the court's rulings here today, I think more information is needed. Need to find out to what extent her anxiety and or insomnia would interfere with her ability to pay attention. For example, it may be that it's occasional. We have nothing in here about the, how often. I would note I think the contrary information would be working in the field that she does for 23 years would suggest perhaps that none of that impacts her ability to function at a high level, and so more questions and answers are needed, and I'll deny the request to strike 4722 for cause. All right, juror number 4816.
We'll withdraw that one. It was based upon just simply the theft victim.
All right, I appreciate that. That person will remain. As to juror 5105, as you indicate, a questionnaire was not provided. Had we done this conference perhaps earlier, I would have most likely done an order to show cause for that individual. It's possible that individual shows up as well. And if so, the juror will be given the questionnaire. So at this point, I'm going to sort of defer ruling on this and wait and see if this individual actually shows up. At that point, can fill out a questionnaire. So for now, they remain in. I don't want to give a benefit to someone who did not fill out this questionnaire by simply striking them for cause. I think they need to come in and explain. So, and I may address that later even if they don't, so.
Understood.
All right, juror number 5258.
Based upon the prior rulings on, by this court, we'll withdraw the request for that person.
All right, thank
to be
you.
excused.
How about juror number 5351?
This person is related to District Attorney Steve Centenario.
Well, prior employee of the district attorney's office. He's no longer employed, if I recall. Is he doing any volunteer work in the DA's office at this point?
No.
How long has it been since he's done that? My recollection, it's been a while.
More than 5 years.
I think it's premature. This is not an attorney in the case. It's not a party. It's not one of the attorneys representing the parties. It is a prior employee of the Waukesha County District Attorney's Office that this particular juror is related to. So it's pretty attenuated. I think more questioning might be warranted, but nothing about that would satisfy the statutory criteria for statutory bias as a matter of law. So I'll deny the request as to 5351, and they'll remain in. All right, juror number 5422.
Your Honor, 5422, there's any number of reasons why this person isn't appropriate for this case. One, the person says that they are retired but failed to provide the last job employment. that they're required to answer as to what they're retired from. 2, the person has only actually finished 8th grade, and so doesn't have even a high school education. It's a complicated case with a tremendous amount of probate information, financial information, credit cards, bank statements. It's not for somebody who has only finished 8th grade. The person also has indicated that we cannot use any college words because, quote, I do not understand, can't really read what the next word is. I quit school, 16 years old, 8th grade. They can't even spell. They wrote the word grand. I think they meant grade. The person also has depression and anxiety, panic attacks, and has just completed last year 2 years of lung cancer treatment, and he has lots of side effects. I'd ask that he be excused.
What's the state's position?
We're objecting to this. I think that this individual has every right to come and serve as a juror, regardless of his educational background. I think this is an inappropriate class exclusion.
He's indicated, Your Honor, that the length of the trial is a problem for him. So for the state to say he has every right to serve, that I understand that, but he's indicated that it's a problem for him.
Out of an abundance of caution, I'm going to grant the request from the defense. This is a multi-week trial. There are 2 separate but parallel investigations, one related to the homicide allegation, the other related to the theft allegations. I think when you look at this particular juror as a whole and the issues that this particular juror indicates, this would not be an appropriate trial. And again, out of an abundance of caution and in my discretion, I'll grant the request as to 5422. All right, juror number 5696.
5696 indicated that she is not available due to family commitments and her 50th anniversary and her stage in life. 5 weeks is just not possible for her at her age at 69. Excuse me 1 minute. Yes, and so also indicated that she cannot handle violent cases.
Attorney Nicolai?
We're objecting to this motion to strike for cause as well. From our recollection, the comment in terms of the hardship of the length of the trial was very vague. There was no detail given about anything, in terms of she's going to be out of the state or things like that. So I think we need more information and that it's premature.
I agree with the state. It's premature. The answers are quite general. And this is not someone who was indicating a work commitment, really even a family commitment. It's very general. Given the age of this individual, it appears that this person hasn't been in the workforce since 1975, and that may in fact be the household may be in a retired status. And given that jury service is an important civic duty, I think it's important to have this juror come in and explain these answers more fully. There's no bias or prejudice that's been identified in any way. So I'll deny the request as to 5696. 5870 was a stip already, and I believe we already addressed the person before that, so I'll turn next to 6382.
6382 would not request a strike for being a robbery victim. But despite that, the person, we still do wish to have this person struck because 6382 indicates that, is there anything about your prior jury experience that would cause you not to want to sit as a juror? Said yes, anxiety, impossible, fainting. Is there anything at home that would cause you to not be able to, or want to sit? Yes, somebody in the family just died. The trial may last 5 weeks. Is that a problem for you? The person says yes, because of anxiety and public pressure if a high-profile case. And of course has the history of fainting. And this is a high-profile case. So we're asking, because this person seems to feel that this would be a problem for him, that the court allow him to serve on something that's less high profile.
Attorney Nicolai.
So I'm a little confused because the response about his experience as a juror contradicts his answers to the question of whether he's ever been a juror, which was no. And then the questionnaire asks about if there's anything about your prior jury experience that would cause you not to want to sit as a juror, and then that's where he writes possible fainting. So I think more clarification on that needs to be developed. This is not an individual who has clearly indicated that he's fainted as a juror before. The high-profile case, certainly part of this court's order involved that the media absolutely not capture any juror's face and not be streaming the voir dire process. So I think that could be something that would assuage this concern if this juror was brought before this court for voir dire.
I would add to what the state is saying that there is a numbered jury order, and so their names will not be identified during the trial, only by number. Of course, the parties have their names and have been able to do any research that they want regarding these individuals. It's really premature based upon the answers that have been provided. More information from this juror is needed so that this juror can provide an explanation and the court can make a more thorough analysis if a request to strike is granted later on. So I'll deny the request as to 6382. Juror number Juror number 6589.
We ask that person be struck for various reasons. First, failed to answer parts of page 2 on the questionnaire. But more importantly, that person is a friend of Deputy District Attorney Leslie Basie, is a friend of District Attorney Susan Opper, is friends with Julie Moulter, who I believe may be a victim witness coordinator in their office. They're friends, not only friends, but they're also clients of this person. I think that that's just unfair to the defense to have somebody that's that close to the various members of the district attorney office on this jury panel.
Attorney Nicolai.
The state's objecting to this request. I believe that all the answers that required responses on page 2 were given. Additionally, I think there needs to be more information regarding this person's relationship with these individuals within our office, but I would also note that none of these individuals are going to be associated with this case in front of the jury. They're not assisting with it or They're not going to be in the courtroom. I would also note this person indicated they were a victim of a home break-in. So I think that this is premature. The only basis for a for-cause strike here would be his relationship or knowledge of the three individuals that work in our office, and we just don't know enough about that.
I agree it's premature at this point. We need more information. I agree with the state's assessment that there are questions requiring an answer. Given his prior answers were likely, they weren't omissions. He indicated the person was divorced and no one lived in the home. It's an if. So I think there's no issue with that, but certainly we can follow up to see if there was some type of an omission. Nothing about the answers would rise to the level of any type of bias or prejudice for or against either of the parties. There was a hardship that was indicated, but again, more information is needed before this court could strike the juror for cause. So I'll deny the request as the 6589. Six, 956 then.
956 is a retired probation officer who's indicated that he or she is not unbiased, number one. Number two has indicated that he or she does have a health problem or disability that affects that person's ability to serve, and that the person wears progressive bifocals and apparently considers that to be some health problem or disability that affects their ability to adequately participate in this trial. Also, the person had a stroke, has nerve damage, the foot gets numb. You can see by the writing on here that the person had a lot of trouble filling out the questionnaire because of this nerve damage and from the stroke, and has a lot of trouble filling out the questionnaire. And of course, the jury will be allowed to take notes here, but somebody who is having trouble writing with the severe nerve damage that prevents them from even filling out a little bit on a jury questionnaire, I just think that's too much to ask. Plus the foot getting numb, I just think it's unfair to ask somebody like that to sit on a 5-week trial.
What's the state's response?
I don't have a position on this one.
I think it's premature, even though this person served as a probation agent, because the specific answer references a specific type of crime that is not the subject of this case. And that was where this individual indicated, and it wasn't even a definitive bias. It said, I might not be able to be unbiased for certain crimes, specifically sex assault. So I'm not concerned about his past employment that way, certainly. More questions are warranted, and I'm not going to make a finding that his penmanship is any indication of a disability or an issue that he has. We don't know if that's just motor skills versus comprehension. I think we need to give him an opportunity to come in and serve and answer more questions. But nothing about his questionnaire causes me to find that there's any type of bias or prejudice that would warrant the court striking him for cause. So I'll deny the request. 6956 will remain in the jury pool. All right, juror 6960 then.
We'll withdraw based on prior rulings.
All right, thank you. Juror number 7000.
Person is friends with Judge Buchenhagen, who is in the criminal courts here in Waukesha County. It's a challenging period of time for him. There's no one to help him for 5 weeks. He also has 18 years of work at Lad Lake, which is, had to call the police, had to testify, was very involved in the criminal justice system. As he said, called the police hundreds of times. He has started a new career in the financial services industry, which doesn't have a very high success rate, according to him. And he has and so he needs to work to try to make it in this new career of his, year 3 of his career. He also has a 1-year-old at home. He had a very challenging first year with that child who was born premature with tubes, infections. The wife has very limited PTO left from her job due to the health situation of that child. And while he is capable and willing, it would be extremely challenging for him. His in-laws are 2 hours away. There's just nobody to help them. So I think he should be excused because he's asking to be excused for great hardship.
Attorney Nicolai.
We'll agree to 7,000.
All right, based upon the stipulation, I won't stand in the way of that, and 7,000 is struck. All right, juror number 7126 then.
7126 indicated that this would be a major financial hardship. She is the primary income earner. She would not be paid for the 5 weeks. She also has 3 children that require transportation for activities. She's indicated that this trial would be a hardship. It would be a problem for her. So I'm asking that she be excused because of the hardship.
Attorney Nicolai.
We have looked at this one. We are maintaining an objection to striking her for cause. I think that her hardship, when you read the details of it on question 53, is more in line with what we've seen on many, many other questionnaires. So we would object to this.
I agree it's premature. When you look at all of the answers as a whole, the fact that there is another parent in the home who clearly must drive because that person's employment is indicated as a driver, 1 child at least driving age. I'm not going to make any assumptions. I think it just warrants further questions and answers. I have denied similar requests based on hardship alone. More answers need to be provided, but none of this rises to the level of bias or prejudice for or against either one of the parties, and it would be premature for the court to strike for cause. So I'll deny the request as to 7126. 7227, there was an agreement to. Any additional jurors where a questionnaire was not filed, again, I'm not going to award to that person being struck for cause because they didn't fill in their questionnaire. I'm hoping they'll show up on the day of trial, fill it in. If not, they may face further, issues with the court, but they'll remain in the jury pool for now. So that takes care of 7301 and 7453. Turning next to 7370.
We'll withdraw that request.
Similar, just based upon its hardship, we need more information, and then being the victim of a crime, right? Okay, that one will remain. How about 7448?
Same, we'll withdraw that one.
Okay, thank you. 7476.
7446.
No, 7476.
7476, thank you, Your Honor.
You're welcome.
We'll withdraw it. The person is hard of hearing, but he does seem to indicate that the length of the trial wouldn't be a problem. The only problem would be his hearing status.
Right, we can wait and see to see if the assisted listening device would be helpful or not.
I
All right,
agree.
thank you, I appreciate that. All right, how about 7503? Should be the last one then.
Obviously, the person has been a victim multiple times. Mugged at gunpoint, also was a victim of identity theft. In addition, this person has indicated that this length of this trial is a problem for him because of lost wages. He's on a commission bonus-based performance, and his inability to do the job could prevent a financial hardship. So we're asking, because it's a hardship to him, that the court excuse him and bring him in for another case.
State?
We're objecting to that. I don't think there's enough information at this point about that financial hardship, and the victim status does not qualify.
I definitely think more questions are warranted, given what this person indicates about the crime and some of the allegations in this case related to the theft charges. I think he would need to be asked whether he could be fair and impartial, but he doesn't identify that at this point in time. And the only thing he indicates is possible length of trial. So it would be premature for this court to strike this person for cause. I'll deny the request as to 7503. I believe I went through all of the requests. Did I overlook anything, Attorney Kukler?
No.
All right, how about from the state? Did I overlook anything from your perspective?
No, but we are raising one other strike for cause that was not contained in the letter.
I don't have one.
Frankly, there was a scrivener's error that we didn't ask to be corrected, but the person that we intended to talk to defense about was actually juror number 613, who knows our witness, Attorney Beth Taylor, and actually hired her to do the jurors' estate planning. Attorney Taylor will testify at this trial.
How do we know that juror 613 knows Beth Taylor?
It's in the questionnaire.
I'm sorry that I don't have that one with me.
I'm sorry, and
Let me take a pause. I'll have my, I have the ones that were not contested initially in the back. Ryan, if you want to go grab that for me, I can look at it, and then if you don't have yours here, we'll just let you look at mine at this point.
Thank you. You have them on your computer? When we get done with the jury. Attorney Nicolai, do you have a copy of the questionnaire that I could look at?
Yeah, can I
Oh, yeah.
email it to you? Or,
Thank you.
Thank you.
Of course. Correct.
Yeah. We agree on that one, Judge.
All right, thank you. Then based upon that, juror 613, and that's the juror ID number, will be struck. Thank you. All right, is there anything else the state wishes to address today?
I wanted to confirm with the court that we will be in the courtroom on the ground floor for the trial?
We'll be in the large capacity courtroom.
Okay, and I know I have a paralegal here who was in that courtroom every day for another high-profile case that this court heard. And so I just wanted to make the request that the seating arrangements mirror that trial in terms of my understanding was that the bar had to be moved back to fit 2 tables, and there was a longer table that was in front so that the 3 state's attorneys could sit next to each other. The only reason I raise this is because I tried a case with a court officer and the courtroom was not configured to fit us all at a table, and there was nothing that could be done about that. We ended up having to, it was not conducive to the amount of parties that were involved in the trial. So I just want to make sure that the accommodations that were made for both defense and the state in that matter that this court heard are going to be the same for this case.
I'll look into that.
Specifically, the front table for the state was longer than this table that's in here because all 3 states' attorneys sat at it. The table behind the state had a connection to the
So,
system.
let me just stop you. The tables that you see in the 2 links are the tables that we have. They are smart tables that, in order to fully function, have to be in a certain spot. My recollection, though, is the larger tables from another courtroom were put into the front spots, but there's no connectivity then when that is done. And then because the way that these were configured, and it's just the technology that we have, the larger tables, like this is why I had you all at the tables that you're at so you all could fit, but had the connectivity. So what I'm saying is I'll gladly try to work that out so that you have the larger tables in front, but if you need connectivity, I can't do that in the front tables. You only have connectivity, meaning to be able to display your evidence from a computer, from the back table. Now, in that other trial, the paralegal took care of all of that. I've already made orders related to who can be at what table or who can be in the gallery, not the gallery, who can be in the well. And so I'm not going to revisit that. That's already been approved. But just so you understand the limitation by putting large tables in front.
Understood, and we will have the same procedure as that trial where as long as the rear table has connectivity, that would be fine, and I think we'd prefer having a larger table for the 3 of us in the front without connectivity.
It will be the same size that you have
Okay.
right now. And I don't have any other tables, and I don't believe we used any other tables. But I'll look into that.
Okay.
Will the defense have any issue if you have a longer table but without connectivity in the front? Do you know what I mean by that?
I do know what you
Okay.
mean by that, but I'm not sure where I'm not in that courtroom, so it's hard for me to envision where we're going to sit. We want connectivity, so we would sit at a table that has connectivity.
All the tables, as they're currently set up, have connectivity.
All right, well,
The
this setup is...
issue is the size of the tables. You will see the table in front of you right now is shorter than the table at which you are currently seated. So if you choose to all sit at the back table because it's a little bit more comfortable for 3 people, I can either remove that other table so there's nothing in front of you. But if you wanted 3 people more comfortably at the front table, it would not have the connectivity to the audiovisual system.
We wouldn't want that, so we'll just keep the 2 tables.
Okay. And we can look.
What?
We'll do all of this offline.
Okay.
We'll make sure we touch base with Zach Tremaine, but I'm about 99.9% positive about what I'm saying.
Okay.
and then look at the schematics we had for that other trial.
Okay.
But that's my recollection, is the front tables were larger but did not have connectivity.
Okay.
It was only the back tables. It's a mirror image of this, but larger, so that, because the jury box is on my right in that courtroom. And so the state would be on the right if you're me,
Right.
left if you're looking at me, and the defense will be on the other side, so.
I also had jotted down having a table for exhibits set up. I think in that trial, there was one kind of toward the front of the courtroom. There are going to be many, many, many exhibits in this case. And I'd like to keep them organized between trial days so that, because we're going to reuse them with various witnesses, so that we can keep them in order and grab them as we may need to.
I'll take that under advisement. I need to make sure we have that availability as well.
Okay. I was going to ask this court respectfully for a refresher on how you want the exhibit process to work, because I think there's a little confusion on our side in terms of what the court wanted ahead of time, and then I know perhaps your practice has changed since that last major case in terms of having exhibits e-filed. So I'm just asking for a repeat of that information, please.
Let's do that discussion offline with the attorneys
Okay.
in the court and my clerk.
I also note, I was contacted by an attorney with Corporation Counsel yesterday, inquiring about some subpoenas that were served on correctional officers. And when I actually looked back into that and refreshed my memory with the last jury status we had, similarly to what we discussed at the beginning of this hearing, the court had made an order that if there were going to be other acts about Magdalena Sabaniak, who was a jail inmate with the defendant, that another acts motion needed to be filed by February 3rd of 2023. And so my question is, given that was never filed, what the offer of proof is for these two correction officers, because I believe Corporation Counsel would be interested in avoiding having them produced if there's not any admissible reason for their testimony.
I'm not going to address that here today. I don't have a motion in front of me. I mean, Corp Counsel knows how to file a motion to quash should they deem it appropriate. At a minimum, the parties should meet and confer over that, and then if there's an issue, file an appropriate motion.
Okay, thank you.
Was there anything else then from the state?
Would the court be able to provide the parties with the list of the first 50 jurors coming in on the 23rd, maybe the Friday before, just so that we can
Yeah, that is
organize
that's a great question. That is my intent, is to, once we get through with this, to talk with the jury coordinator, and tell you who the first 50 will be. When they come in, though, they will be randomized. But we'll know the 50 that they come in, if that makes sense. I'm doing 50 per day. That was in consultation with facilities, given the court construction process, and parks and planning, because they're in charge of all the parking and all of that. So given some of the limitations, I agreed that only 50 would come in per day. I've worked with them to make sure all jurors have adequate parking, and along with the sheriff's department, they've been phenomenal to make sure the accommodations are here for all of our jurors. And so it will be 50 per day until we have the magic number of 30. Once we know we have 30, maybe it's the first day, maybe not, then the parties will do their strikes, their preemptory strikes.
Thank you. That's all I have.
All right, how about from the defense, anything?
Yes, Your Honor, a couple things. First is document 213 that we filed requesting that Dr. Sameh, S-A-M-E-H, be allowed to testify by Zoom due to her autoimmune condition. Her I think her risk management attorney has reached out to us and asked for special consideration for her.
My understanding is she's in the medical field and has an active patient practice where she sees people, is that right?
Maybe Attorney Galavis could better answer this. He's the person that
I don't want to make assumptions, but
subpoenaed her. He knows the facts of that better than I do.
Judge, that I don't know at this, today, whether or not she still sees patients because of her medical condition, but back in the day, she was one of Ms. Hernan's providers and did see her on occasion. Today, whether or not she's doing that, I'm not sure. I could find out. She is represented by legal counsel.
what, and I don't have any motions related to this, but how long do you anticipate her testimony would last?
An hour?
What's the state's position?
I'm sorry, I didn't hear counsel's answer.
1 hour, he said. So this apparently is a treating physician of the deceased. And I don't need an answer yet here today. I would have preferred a motion. I mean, my specific response to that request was I didn't have enough information to either grant or deny it, and I didn't know the state's position. Just like I didn't address some of their requests because I didn't have a motion in front of me, I think it's important that the parties meet and confer on this, and if need be, an appropriate motion be filed, since our purpose of being here today was really for the jury questionnaires.
Correct. If I remember right, the state didn't have any objection to the Zoom request.
Well, I don't know. They didn't.
That was not relayed. We were provided this letter, and I indicated that we would look at it, but I did not. My concern is showing this person physical exhibits, because there are many medical records that I won't be able to hand someone on Zoom. That's my concern.
Well, meet and confer. Perhaps there can be an agreement on whether this person testifies by Zoom or not. We clearly have the capability, okay? I have the ability through the Zoom application to share, just as you know, exhibits for this person. It's a little bit trickier during a jury trial. You have to think about the person's on the screen. It's a very large screen. Okay, and they're on both screens in my courtroom, along with the monitors in the jury box. And so if there's an agreement, or if I allow this, do I need to give some type of limiting instruction or cautionary instruction to the jurors about not putting more or less weight because they're remotely or because of how they're depicted? Every witness in the courtroom sits, it's to my left here, but downstairs it's to my right. And they're in person and they're life size, not, I don't know, 10, 20, 50 times bigger on the large monitors. So there's some real practical considerations. We obviously did a lot of the Daubert hearings but we had all those witnesses and it was just for the court. I'm not opposed to it, but I want the parties to look into it. I'd prefer if we do it, there's an agreement and you address things like how will exhibits. Is there an agreement on what the exhibit is? Can it be provided to her ahead of time? Or simple questioning on the day of the testimony, we can confirm. Where will she be testifying from? I do not want it from her home, right? If it's an office and can it be, and no one else is in there with her. If she has an attorney, that's different, but I need to be provided with that information. So there are way more questions that I have. So I'm not in a position to be able to answer that here today. Whatever the request is, though, if there is a renewed request that she appear by video to testify, that must be filed no later than Wednesday morning at 9 a.m., along with any other motion on this witness that I declined to admit here today. That was the addendum. I indicated I'd need a motion. Same thing for the state. If Corp Counsel is going to be filing any type of motions to quash, everything needs to be filed by Wednesday morning. at 9 a.m. so that I can appropriately schedule a hearing, whether that be the morning of, whether that be we get the jury picked first and then I address this, like Wednesday morning or something of the following week. I will look at my calendar. I'm very full, trying to get a lot in before this trial starts. But that's how I'm going to address all of these things. Were there any other issues from the defense at this point?
Yes, one other issue, Your Honor, is that we're asking this court to order that we have a presentation of a trial schedule that puts forth the witnesses and the dates and the times that the witness is anticipated to be called to the stand. Of course, things are fluid in trials, so there can be changes to that. It's very difficult for the defense with a trial of this length to not have any indication at all from the state as to who they're going to call when. I recently just concluded a 3-week trial before Judge Waterman up in St. Croix County. I brought with me the letter he issued to that effect, indicating that he expected the attorneys to confer and give a proposed trial schedule so that he would know who was going to be called when, have a good idea how long they were going to testify so that we could run the trial in an efficient fashion and so that people could be properly prepared, knowing that there's dozens of witnesses. And he indicated, of course, that the attorneys should be realistic about the length of time that they anticipate for direct and cross. So he knew how his courtroom was going to be run, how he was going to run his courtroom, and what the days were going to look like, not just for him, but for the attorneys. And I ask that this court consider that in this case, because obviously there's a lot of witnesses.
I'll take it under advisement. I'm getting this request of, a week, not even a week and a half before the trial, and I'm mindful that both parties are preparing. I would have certainly entertained that had it been a request when I did the trial order. I don't know what type of time commitment, resources it would take the state and the defense to do that. So I would just ask that you meet and confer on that. Maybe there's some agreements you can all reach. Maybe it's just a list of when you're, the order. I don't know. But for a trial of this magnitude, I think to ask this court to do that at this time, I think is kind of unfair to the parties.
Judge, we did talk about this, and that's not something the state is agreeing to prepare for the defense, so it would require a court decision at this point.
Right, we did bring it up with the state, Your Honor, and asked if they would work with us on the order of witnesses, and they refused.
Well, again, this should have been raised months and months and months ago. This is the second time a case has been scheduled for trial, so I'm not going to issue that order. It's a great idea, and under other circumstances with ample time, I most certainly would have granted it. But I think to do that, it is, October 13th, the trial starts on October 23rd, would be to take away from the prep time that has already been set aside by both sides as it relates to this.
Would the court indicate that at least on a daily basis, we could be provided with the witnesses that would testify the next day?
Not at this time. So again, that request should have been made months ago. I'll wait and see how, bottom line is I set aside what is a portion of 6 weeks, 25 calendar days, so that there's ample time and I'm not going to interfere at this point or order the parties and micromanage the way that they call or the order that they call their witnesses, not at this late stage. Now, I would like to raise one other thing. I did have my clerk send to the parties the revised script for jury selection. It takes into account prior hearings. It takes into account that the process for jury selection is a little different. It's not different, it's just that the prior script anticipated remote viewing by jurors. Obviously, we're not doing that, so I took out some questions that were related to that. I have some instructions that, for purposes of the parties, saying that we'll bring in 50 at a time, that I will be questioning all jurors. The seating arrangements downstairs, because we do have a little bit more room in the well, will be that, and it's in the trial administration order, but we have those in the jury box. We have 2 rows, I believe, in front, and then I'll be utilizing 2 rows, right? I think it's 2 full rows from right to left or left to right, however you're looking at it, with jurors, and then there's limitations on who sits where, et cetera. So just be mindful of that, but it will require the parties to be able to, you know, swivel in their chairs to look at jurors who are providing answers. I contemplated, you know, just doing those, what we would call in the box, whether they're in the actual box or the rows in front of it. But I really want to get through 50 jurors, and I think it'll be much easier, given the length of the script, if all 50 are questioned. So we'll start with those in the box. They'll go through their biographical. We'll continue. They'll all have numbers on. I'll identify them by numbers. We'll go through all of that, and then those specific questions will be asked, and we'll go from there. That hopefully takes us, you know, no more than a day for each 50, but I'll be prepared to adjust if need be.
Will the court be referring by pool number?
So what'll happen is when they're randomized, they'll get a jury sticker which starts with 1
Oh,
and
so
go
it will
through
be
50.
different.
And that's how I will be referring to them during the jury selection process. Depending on, that can only happen the day of, and I believe Lauren will be able to put a spreadsheet, at least of numbers together, and so if, I'll do my best, maybe I'll cross-reference with a second number, like the, what's the top one?
It'll have the juror ID number on it.
The juror ID number.
Excuse me, the pool number.
The pool number.
And then their new randomized number.
So they'll have their pool number and their randomized number. So I'll do my best, at least initially, to start with both. Because these jurors will still have their questionnaires. They're going to get a supplemental questionnaire, as I've told you previously. I don't know if I've sent that to the parties. I was working on finalizing that. It's pretty simple. One is, please review your questionnaire. Is there any answer that would be different sitting here today or that you would like to supplement? The second one was based upon the request of the defense to recognize any other juror. I was having a discussion about what number they would see, if any, and I'm going to require that they get their randomized number before they're given the supplemental jury questionnaire, so they can say, oh, I recognize juror 43. Some of these people, they truly recognize each other, might even be able to do that without numbers, but I thought that was important. It's a question in the script as well, but at least you'll get that ahead of time. They'll fill those out. We'll make sure all the parties get copies of those supplemental before the jury's actually brought in. I know for myself, I will have a folder for each one of the jurors, and that will be put in, and I will be able to, you know, look at all of that. It'll be up to you how you all have those, whether it's electronically, given the flash drive that was previously provided, or if you print off copies on your own and have, you know, like a 3-ring binder or folders or whatever it may be. But I would highly encourage you, however you're printing them out or however you're doing it, that you have at least those 2 numbers in your spreadsheet, for example, or somehow readily identifiable on the first page, so that we're not kind of fumbling through all of that. And I'll make sure once I confirm with Lauren, our jury coordinator, that you all get a copy. It's 2 pages, or it's 2 questions for the supplemental, and then it has a number of pages with just lines so they can handwrite, and it's hopefully helps with legibility. But that's really all I have. I do intend to start each day at 8:30. My experience is typically the jail on trial days will have Ms. Kurczewski available. I'm hoping it's not like it was today and late, but that she's here and available no later than 8:15 each day.
Judge, on your questionnaire or your script, could I just ask one thing on that script?
Sure, let me pull it up. Go ahead.
Thanks. When you're, get to page 4 on that script, and you discuss whether the potential jurors know any other attorneys on the district attorney staff, would you also please mention when you come to Attorney Galaviz and myself that I'm with Kukler and Cotton, and see if anybody knows any attorneys in my staff?
Usually I have a question that says, would you please identify where you work? I can add that.
And I'm looking at page 4 where
Yep.
you, number 10, do you know any other attorneys on that staff, speaking of the district attorney, but nothing about our firm? Just to be sure.
Attorney Galaviz, what's the name of your firm?
Galvez Legal.
Is it just you and your son, or is there anyone else?
Just me and my son, Adam.
I know last time, because of this attorney, she quashed her subpoenas for these documents. Neither gonna testify.
I obviously know one other attorney, Anthony Cotton, but remind me who the others are, and I'll just list them in this
Anthony
question.
Cotton, John Binder,
Binder, right?
Binder,
Okay.
Brad Novreski, Novreske, and Patrick Campbell.
C-A-M-P.
Bell.
So this is how I'm modifying that question. It's 13. The defendant is represented by Attorney Pablo Galaviz and Attorney Donna Kukler. Attorney Galaviz is employed at Galaviz Legal along with Attorney Adam Galaviz. Attorney Kukler is employed at Kukler and Cotton along with attorneys Anthony Cotton, John Binder, Brad Novreski, and Patrick Campbell. At times during the trial, paralegal Kate Risto may be joining the defense team in the courtroom.
That's great. It's Binder for the record.
Binder. I
Binder.
do that all the time.
That's right.
I'll have to give myself a phonetic reminder. And then part A of that says, are any of you related either by blood or marriage to Attorney Pablo Galaviz, Attorney Donna Kukler, or any other attorney just named? How's that? The second part of that is 14. Do you know Attorney Pablo Galaviz or Attorney Donna Kukler or any, is it all right if I just group them, or any
Yes.
of the other attorneys named?
Yes.
And then I had specific questions as it relates to Kate Risto.
Right. Okay, thank you.
Any objection from the state?
No, I would just note on that same page, Charlie Hoffman needs to be replaced with J.J. Crawford.
Okay. All right, I'll do a search and replace for him
you.
and make sure it's anywhere else. Anything else as it relates to my script?
No.
Not from us.
All right, then absent any additional filings, we'll see everyone on Monday, October 23rd at 8:30 a.m. Yes, Attorney Galaviz?
Judge, going back to that request by Ms. Kukler to try to get the state to give us a time frame as to when they're going to be calling their witnesses or when they're going to be able to conclude their case. Back when this trial was set in February, March of early this year, the civil attorney representing Dr. Smith and Dr. Albulal filed a letter with the court. He was basically upset that I couldn't give him a time frame as far as date and time that I'm going to need the doctors to testify. So he filed a letter with the court. And you, based upon his letter, quashed the subpoenas because I couldn't comply with his request because I had no idea when I was going to call these witnesses because I have no idea when the state's going to finish their case. So
That was
he's-
based upon the fact that it listed an entire 5-week time frame.
Correct. And I was working with him via telephone trying to confirm like the week and possible day that I was going to need the witness, and he basically told me that wasn't good enough.
Let me be clear. I expect the parties to meet and confer, and as officers of the court, understanding you are taking not just this court's time, your time, but members of the public as jurors and the victim, and Ms. Kurczewski's time, that you work this out between the two of you, or between these two teams, and come up with a scenario that works. That's reasonable, and I think that's what attorneys are expected to do. I'm not entering an order, but I do expect the parties to have some reasonable time frames, whether it be we expect 5 witnesses today, or whatever it may be. But you got to try to work through this first before I step in.
Correct.
Judge, we did that. I want the record to show that we did do that. And we had a discussion, and I told Attorney Kukler over the phone, we anticipate having 8 to 9 days of testimony. Depending on how long jury selection takes, that will give a very clear window for the defense when they should be ready to begin calling witnesses. That's been done.
What I would expect to happen, since I'm getting a lot of clear, we're not going to give you much more than that, is after each day, you just give everyone, both sides, give a ballpark of who you expect to call the next day. I think that's reasonable, right? And I appreciate the 8 to 9 days of testimony. I think I recall that now. That might have been said. I think that's probably why I was hopeful we could get this done before Thanksgiving. But that's all I'm going to do at this point, okay?
Judge, there's one more topic that my client wanted to bring up to you, so I'm just speaking on her behalf, and that deals with court docket 229.
If that's her letter,
Correct, that she
she
personally,
needs to meet and confer with all of you, and if you think an appropriate motion needs to be filed, I'm not addressing it. That's why
Okay.
she has an attorney. I appreciate she filed it, and I appreciate she did what I said I would expect to happen before any issue would be raised, but requests need to be made appropriately, and she has counsel, and she needs to work with her attorneys. So, if any motion needs to be filed as it relates to that, it needs to be filed by Wednesday morning at 9 a.m.
yes, Judge, thank you.
All right. Thank you, everyone. That concludes the hearing, then we are in recess.
Thank
Have
you,
a
Judge.
nice, have a nice weekend.
See you.
Oh, actually, one other thing. Sorry, there's a reason this TV's up here. We have the ability in the courtroom to have, thank you, Madam Clerk, 2 TVs, and if you can see, can you put on the questions, Madam Clerk? I want to make sure that the jurors who are in the gallery are able to see those. So that will most likely only be there for jury selection, but we have these smart outlets on both sides. I just only brought in 1 TV for purposes of today. But during jury selection, to make sure the jurors can see that, it will also be on those monitors on each side, because jurors will be in rows across. Thank you, Madam Clerk. I forgot about that. All right, now we're done.
Thank you.
Have a good day, everyone.
You too.
Jury selection.